Friends, we welcome you to the Legal Breeze. Today we will be talking about an important topic which has a direct relationship the Constitution of India, particularly electoral reforms, defamation, freedom of expression, democracy, all these things. You would have guessed this topic by this time. Everybody is talking about Rahul Gandhi's disqualification case. What is it? How is it constitutionally valid? What are the remedies and how we can go forward? These are the issues we will be discussing it today. Let us go to the case straight away. It is alleged that Rahul Gandhi has made up remarks that those who are having Modi as a surname are thieves, something like that. And specifically, he said Nirav Modi and one more Modi and Narendra Modi are thieves, something like that. For that, whether some other Modi residing in the state of Gujarat and MLA can go and file a defamation case, particularly criminal case. Now, there is a principle called ejusdem generis. What is this ejusdem generis? When I make a specific enumeration followed by a general word, the general word has to be restricted or confined only to the specific narrations what I have made. What is the specific enumerations here? This is only Nero Modi and Narendra Modi and one more Modi. And if at all, if I am using the word general word Modi, thereafter, the Modi general word which I have used should be confined only to the specific enumeration. This is the principle. Even if you stretch it beyond that, it is not at all going to be helpful. So, whether a third party can file a criminal case, whether it is maintainable, all these things. Why Congress party raising all these things at this juncture? They could have raised it all these things before the magistrate himself. We do not know whether they raised it and whether the magistrate ignored all these things. We do not know. But anyhow, this is a ground of appeal that they are filing it right now. Second thing, whether defamation should be viewed such a serious things, particularly when people are making electoral things. That's the question. Third one, it's an ethics. People should not make any personal attack. Whether Rahul Gandhi alone is doing this, that's a $1 billion question. And just because Rahul Gandhi, whether this case has assumed this much proportion, the answer is yes. Previously, there are many MPs, at least few MPs I understand they have convicted for this, but nobody raised alarm about it because those who high, occupy high position are given more importance in this society. An MP is an MP, no matter whatever it is. But since it is Rahul Gandhi, it is believed that people have given the heightened importance to this. What Constitution says about it, about the disqualification of MPs? There are three modes of disqualification of MPs enunciated under our Constitution. One is something called Office of Profit, where you can look into all these things. Please go to Article 102 class 2 subclass C and Article 191 of this Constitution. 102 talks about disqualification of MPs, whether it is Rajya Sabha or Lok Sabha. 191 speaks about MLAs, that is in the Assembly, legislature. Right? This we need to bear in mind. For Office of Profit, it is not the Lok Sabha Speaker or Rajya Sabha Chairman or that for that matter the Assembly Speaker can take a decision because he himself or herself happens to be an MLA or MP for that matter. So, nemo sua in sua causes arises. What it is, no man shall be the judge of his or her own case. So, therefore, the responsibility has been vested by the constitutional framers in the hands of the president and the election commission. Very important. So, president has to do that, but president cannot do that on his or her own. It shall be acted upon. The president shall act upon based on the advice tendered by the Election Commission of India. This is very, very important. Please note the point. In all, generally, you would have seen the president is bound by the advice tendered by the cabinet council. But here, constitution makes it very clear. The president shall act only in accordance with the advice tendered by the Election Commission of India. So the president has no discretion at all. This is very, very important. So next one is given in the hands of the speaker or the presiding officer of the legislative house, whether it is parliament or legislature. What is it? It is called 10th schedule. How it is attracted? There is something called anti-defection. So up to one third of a political party breaks or merger, then they don't attract any disqualification. But anything falling short of it attract disqualification. And here the speaker almost act as a tribunal. Of course, his or her decision is liable to be judicially reviewed. We have good number of cases. We will come back to that little later. The third one, this is what we are all talking about today. This is coming under the RP Act 1951. The RP Act section 8, 9, 10, 11 talks about certain disqualifications. In fact, this is also electoral offense to some extent. When a person has been convicted of any of the offenses listed between section 8 to 11, then that person has to incur disqualification and his or her seat stands vacated the moment he is getting disqualified. Or sorry, the moment he is getting convicted, the disqualification and conviction runs coextensively. This is very important. The moment a person gets convicted, his disqualification starts. There is no time limit. So that's what very important. All of you should take note of it. Certain important case, I think we all of us should remember in this regard, particularly about this conviction under RP Act is concerned. Lily Thomas case, Lily Thomas versus Union of India, way back in 2013. There is one provision called Section 8, subsection 4, which has allowed 90 days time for any person who has been convicted. Till then, he or she need not to be disqualified. But this provision has been struck down in this Lily Thomas case as unconstitutional. Then, but at that point of time, UPA too was in power and they wanted to bring an ordinance. Same Rahul Gandhi opposed it. That I think that should have appreciated because he himself happens to be an MP. He was not biased. He wants to be very transparent and accountable. But the same thing now it is sitting back. Whether he should oppose it or permit it, it is left to him, and we will leave it to him. That is one thing. Second thing, low prahari case. This is very, very important. This I think this has happened way back in 2017 or 2018. Just kindly check it out. This case has given one more important pronouncement. This is again by the Supreme Court of India. In this case, they said the disqualification cured once a higher court gives a stay. That's very, very important. Now, till now, in Rahul Gandhi's case, I am afraid I don't have any information whether he has got any stay. Or when the case get quashed or reversed, acquitted, discharged, I think the disqualification uh, gets cured and he can be restored. His or her seat can be restored. What is the classic case? Muhammad FAIZAL, an MP from Dakshadweep. He was convicted for an offense relating to attempt to murder or murder, something like that, and he has been given 10 years of imprisonment. But later on, the Kerala High Court has reversed it, acquitted, and his conviction, since his conviction has been cured or set aside, he was acquitted. His disqualification got set aside or cancelled and his seat was restored very recently. Though there was certain delay, but that is totally a different matter. Government shall not take its own sweet time. because the disqualification and the conviction runs coextensively. The moment the conviction gets set aside, the disqualification also becomes ab initio, void ab initio. This is what all of us should remember. So electoral reforms, very, very important. So three modes of disqualification: office of profit under Article 102 or 191, then anti-defection law under the 10th schedule, and conviction under the RP Act. And again, you should remember, it's not all conviction results into disqualification. Conviction of not less than 2 years of imprisonment, a sentence, an offense which is punishable at least 2 years of imprisonment alone or more than that gets the disqualification. Anything lesser than 2 years, even one day falling short of it, will not attract disqualification. So we hope this information is useful to you. Please share it with your friends. God bless you all. Thank you.